Yes. Thank you very much, Michaela. It's a pleasure to be here. I was particularly missing the University of Oslo since finishing my master's degree here, so it's genuinely great to be back. With no further ado, today I would like to shine a light on the legal side of things and chart how there are similar issues, both in terms of classic intellectual property and in terms of novel data governance, that pose problems that may be solved through a shared language and a common understanding of some legal norms. The goal right now will be to chart the progress of some of the EU's newest laws, namely the DGA and the DA, discuss some of their central provisions, and see where that could lead us in terms of data governance. Up here. Thank you. So we'll begin by looking at the intent of the legislator and then seeing how that intent corresponds to actual changes in the technological landscape. Then we'll discuss a bit more classical problems regarding intellectual property rights that persist in data. We will then move on to some more novel considerations that stem from the Data Act and the Data Governance Act. And then we'll see how all of that relates to the running issue of interoperability. We'll round this discussion out with a showcase of a legal ontology that can be used to establish a common top-level framework that can ameliorate some of these issues. So first off, before we talk about the laws and about the requirements, we need to understand why they exist. So with this in mind, we can turn to the EU's digital decade problem and its strategy for the digital decade. This is a little infographic called the Digital Compass that quaintly summarizes all of their goals. And we are mostly concerned with the south-facing side, which is that the EU seeks to have much accelerated intake of big data, AI, cloud and edge services, and so on. In a bit more specific terms, it wants, by the end of the decade, to have 75% of uptake of big data in businesses, which is more than 5 times as much as currently, around 5 times. There is also a need to more than double the intensity of cloud computing service uptake, almost a tenfold aim at artificial intelligence uptake, and a desire to see SMEs almost universally adopt some level of digital intensity. But obviously, since none of these statistics have been reached yet, there must be something preventing that. So the main purpose behind the newest slate of legislation from the EU has been to overcome what they identify as impediments to these targets. And we'll see how that works in a bit. But for now, we can also look at the technical landscape, the technological changes and trends that have elicited new problems. First of all is the rising importance of the concept of data as a product. And more specifically, we can note that there's been somewhat of a shift in data architecture where monolithic data lakes have been slowly giving way to a new concept that is data meshes. Now, rather than looking at a much more complex schematic of what a data mesh is, we can use this simplified graphic here. So we can look at data meshes as a simplification and a greater granularization of data products, where traditional data platforms are usually a monolithic pipeline that starts with data ingestion, has analytical processing and data warehousing built in, and only offers a final report as its end product to users, without much in terms of picking and choosing individual data sets. A data mesh compartmentalizes all of this ingested data into concrete domains, which are individual data sets that are immediately accessible to users for use in whatever application that they may wish to apply them towards. In other words, what this means for the ecosystem is that there is more granularity in data transactions. Data governance has been decentralized and now involves more stakeholders when data meshes are employed. There is a shift towards federative governance of data sets. And naturally, there is also an increase in data sharing and data reuse. Another notable development that has legal ramifications is the increased deployment of digital twins. One definition that can be applied to a digital twin is a virtual representation of real-world entities and processes which are synchronized at a specified frequency and fidelity. In other words, these are ongoing simulations that tie a physical object or a system to its virtual representation. And they are based around the idea that data itself also has a very important circularity element to it. Data from the use and manufacturing of a physical object can be recycled to improve the loop between design, manufacturing, and testing via the deployment of a digital twin. Often these digital twins are deployed as part of multilateral partnerships between several entities, and thus they often also involve collaborative contributions towards the simulation and towards the individual physical objects that are being tracked and measured. And of course, the more stakeholders become active in simulation and a simulated environment, which may go well beyond a single object and encompass entire cities, ports, harbors, the more we move from a single digital twin concept to an entire data space. A data space, in turn, has been recently defined under the newest Data Act proposal as a purpose or sector-specific or cross-sectoral interoperable framework of common standards and practices. In other words, data spaces bring together various actors who establish common rules and a common language to facilitate data sharing and make it possible for a greater intensity of research and a greater efficiency of civil society initiatives. So from taking all of this together, from looking at it as a whole, we can see that the technological landscape that the EU must somehow regulate has now come to focus on the concept of data as a product, and that circularity and reusability, which were traditionally more physical concepts tied to industrial manufacturing, are now relevant for data itself in the digital value chain as well. We can also see that there's been a market shift towards decentralization and federative data organization, which means that, of course, when you have multiple stakeholders sharing and governing data, they need to be able to communicate in a common language. Otherwise, they cannot jointly govern anything. And all of this leads to a need for novel laws that can govern and facilitate data transactions between these multitudinous stakeholders that are now involved in data transactions. And also, there must be trust between them. Otherwise, even if they can share data, nobody will want to share data. Now, we can move on to the actual legal dimension of this issue, and we can identify what the law as it is has to say about these about the data governance, and what the coming new laws, such as the Data Act, will change. First off, we can start with the more classical dimension of intellectual property rights. It is good to note that data under classical law has no such thing as ownership attached to it, in the sense that nobody really has data as their property, but they do have it as their intellectual property in some cases. It is possible for intellectual property rights to attach to compilations of data or to specific formulations of data. But what is important to note is that instead of terms such as data owner, law always involves other concepts such as data holder, data controller, data recipient, data user, and so forth. So this is just something that must be clarified straight off the bat. No ownership in the classical property sense. But beyond IPR, there is also the possibility for novel substantive rights to attach to data. For example, the newest Data Act, which we will focus on in more detail shortly, has provisions that grant holders and users of data specific access and portability rights and obligations. And whenever the law is silent or there is ambiguity, contractual agreements are used to fill in the gaps that are left by IP and data governance legislation. So this is how the legal landscape looks in general. And in furtherance of the legislators' goals, the EU has decided that to advance its agenda, to achieve its objectives and its targets for digital uptake that we mentioned earlier, it needs to ensure interoperability of data in diverse data spaces. It needs to facilitate data access and reuse, and it needs to establish trust in data sharing and data intermediation. Separately from these stated aims, which can be found in the Data Act and the Data Governance Act, legal scholarship has also identified the need to resolve certain outstanding uncertainties regarding how intellectual property rights subsist in data and data transactions. Notably, first, the very basic question is, what intellectual property rights can be in data? What can we see? Because it is certain that you cannot copyright pure data in the sense of factual information. But of course, you can copyright data sets provided that they fulfill criteria such as being original works of authorship. But there are open questions that still haunt the realm of data. For example, what of machine learning models? Whether machine learning models are just formulations of mathematical abstraction, whether they are creative and inventive in their own right. And beyond this issue, which could take up a whole presentation in and of itself, there is also a question of whether the current mechanism of governing data via data licenses is appropriate to begin with. since contemporary data licenses are based on the model of copyright licenses. And since copyright licenses for software assume that software is copyrightable, rightly so, there is a question whether the same assumption could be made for data, and if not, whether we should be basing our data licenses on copyright licenses. If something is uncopyrightable by nature, then it is also unlicensable by nature, which means that these data licenses are not quite IPR transactions, but more simple bilateral contracts under contract law. These ambiguities, these uncertainties certainly need to be cleared away to enable data sharing with greater certainty in the future. Moreover, there is also the problem of actually keeping track of the various intellectual property rights across the digital value chain. Namely, as we have already mentioned, technologies such as digital twins involve collective contributions to data sets. And the question is, when do collective contributions give rise to new rights? Are there going to be cases of shared rights arising out of collective contributions? And what will be the threshold for such developments? Further, there is also some question regarding whether mechanisms developed to solve these issues of collective contributions in software licensing, once again, software licensing, can be developed to also address collective intellectual property rights in data. So just like how software licenses deal with the concept of joint ownership, perhaps an analog for this is also necessary to properly deal with data and IPR within data. Further, there is also a problem related to the tracking of a great number of data transactions, having a constant view towards who has authorized what data for what use is very hard when these transactions happen at incredible speeds and in great numbers. So automated solutions like smart contracts, for example, have been noted to be necessary for handling data licensing and rights clearance. But as of right now, there is also a lack of mechanisms and legal requirements that can say what smart contracts should look like and what criteria they should fulfill. So with these issues on the IPR side in mind, we can now turn to the new wave of legislation and see how that will further serve to either confuse or relax us, as the case may be. First, we can take a look at the Data Governance Act, which is already in force from June of last year, but which will be applicable from September of this year. The Data Governance Act is mainly concerned with three elements. The first is a regime for the reuse of public sector data. The second is a licensing regime and provisions for data intermediation services. And the third is a voluntary regime for data altruism services. Of these three, the most relevant for industrial flows of data, and the one we'll be focusing more on here, is the second one, the licensing regime for data intermediaries. But before we can talk about that, of course, we need to clarify what a data intermediary is. It's defined as a service which aims to establish commercial relationships for the purposes of data sharing between an undetermined number of data subjects and data holders. In other words, intermediation is when an entity seeks to build a bridge, so to say, between some entity that has data and another one that wants that data. The EU sees these intermediaries as being cornerstone of a digital economy that it seeks to foster. But at the same time, it also feels that these intermediaries must be very strictly regulated so that they are trustworthy enough that people will want to use their services. And that is why the Data Governance Act sets forth a very large list of requirements on data intermediaries. Among them, specific interoperability requirements that we'll mention in a bit. But we can also note here that these requirements are not at all light. They're in fact very challenging to adhere to. So these requirements involve a notification procedure, which is probably the simplest part. If you are doing data intermediation, you are expected to notify the relevant competent authority as to the parameters of your operation, who you are, when you will start your activity, what you will be intermediating, so on and so forth. But the crucial thing to note here are the neutrality requirements, where these requirements involve such aspects as having to spin off data intermediaries into separate legal entities that offer no other services beyond data intermediation and anything that strictly facilitates data intermediation. No other value-added services, no transformation, nothing. Requirements that state that data intermediaries cannot use data that they intermediate for any other purpose other than putting it at the disposal of data recipients, and also stipulations that they cannot process the data beyond very limited reasons, such as ensuring interoperability for that data. So there is a specific exception that data intermediaries can actually change data formats and otherwise involve themselves in the data flow only in as much as it's necessary to ensure interoperability, which just reflects the first notion here that interoperability is of vital importance, since it's an exception under these rules. But beyond these neutrality requirements, data intermediaries also have obligations to offer fair, reasonable, and non-discriminatory terms of service. So their prices and their contractual terms cannot discriminate or have burdensome provisions that are unfair to other actors. And they, of course, as intermediaries, will have to implement technical and organizational safeguards and measures, again, to ensure security, reliability, continuation of service in the event of insolvency, and so forth. Also, to ensure access to their data for holders and recipients in the case of insolvency. But even then, these rather burdensome, in some cases, requirements pose open questions and challenges, including how data intermediation services would actually function in a competitive market setting, and whether, due to their the restrictions on their activities, they will be viable, whether they will be able to sustain themselves. Also, it is currently unclear whether it's possible to turn the intermediaryship label from something that only imposes obligation to something that also offers benefits. For example, in the case of digital innovation hubs, where we at KU Leuven are currently working to figure out how a federation of European data spaces may function, an open question is whether those data spaces that are very much oriented towards R&D and servicing SME experiments may benefit from provisions such as preferential access to public sector data, or possibly some leniency in terms of sandboxing and safe harbor provisions. But until this can be clarified with the Commission, there are still other things to focus on, including whether the DGA offers sufficient preconditions for these intermediaries to be considered trustworthy, to establish common standards across data ecosystems for interoperability, and to actually spur data sharing. But rather than going too deep into the Data Governance Act, we can instead turn to the upcoming Data Act. It's currently in trilogue negotiations. There are new versions regularly being put out, so it is liable to change at any moment. And what we say today need not be relevant a few months from now. Well, parts of it will remain the same, hopefully. The Data Act is curious in that it doesn't just have procedural obligations, it has new substantive rights, but it's also a bit more particular in its scope. The Data Act is only geared towards regulating connected products, which it defines as items that obtain, generate, or collect accessible data concerning their use or environment, and that are able to communicate data. This chiefly, but not solely, refers to IoT devices. That's a very simplified way of looking at it. Of course, it's not synonymous with IoT device, but that's one way of understanding this. Then it also regulates related services to these connected products. Related services refer to digital services which are interconnected with the product in such a way that their absence would prevent the product from performing one or more of their functions, and which involve accessing data from the product. So basically, the software component that enables hardware devices to fulfill their functions is a related service. Now, there are questions as to this definition, whether the related service has to deal with a core functionality, a reasonably expected functionality, or any functionality of the connected product, but that is not something we need to go too deeply into. With the scope clarified, we can also see who the Data Act, how the Data Act categorizes participants and roles in the data ecosystem. So, firstly, there are users. Users are those persons, natural or legal, that own a connected product or receive a related service. We can think of them as consumers, but of course, they are corporations that use IoT devices in the course of manufacturing, not just individuals in their own homes. Then we have the data holders. Data holders are those persons, legal or natural, who have the right to use data from connected products and the obligation to make available this data to users or recipients. So whoever has the data is the holder. Data recipients, meanwhile, are straightforwardly defined as those persons who have who receive data from data holders. Now, with these sort of roles clarified, we can see what the actual obligations are towards them. The first is the right to access. It's a novel right under the Data Act that says that users should always be able to access and share the data that they generate through the use of connected products and related services. Now, this is ideally supposed to be a right to direct access, so that the users will be able to access this data without going through anyone, including the manufacturer, the data holder. But it is also possible that if they have to go through someone, then at least the costs upon them would be minimized and certainly not go beyond compensating the technical cost of making the data available. There are exceptions to this. For example, data holders are not expected to allow access to data that is derived from complex proprietary algorithms. This is a concept that mostly refers to data generated through sensor fusion, so the synthesis of multiple different sensors, not just the same sensor repeated over and over again. But of course, this access right on the side of users is concomitant with the obligation of holders to make the data available to users. Then the other newly phrased, I should say, not new, right, under the Data Act is that of portability. The Data Act rephrases a right originally found in the GDPR and endows users of data processing services with the newly reformulated right to switch these services to receive their data and share it with third parties, and to do all of this without commercial, technical, contractual, or organizational obstacles, which once again brings up the question of interoperability. For this right to be fully realized, the data that is given to users from one holder must be made readable and interpretable by whoever the user wants to approach and switch to. Now, the Data Act also has other obligations. For example, it has data sharing obligations between private enterprises and the government under cases of exceptional need. So whenever there is a need to either respond to an ongoing emergency or to prevent or recover from an emergency, the Data Act gives public bodies, EU institutions, the right to request such data. And consequently, it does include safeguards that this request should be made for specific purposes with specific temporal limitations attached to it, and that it should be accompanied by specific guarantees for trade secret protection via either technical or organizational safeguards as appropriate. The other innovation in the Data Act is a novel fairness regime for data transactions. Once again, it imposes fair, reasonable, and non-discriminatory terms for data sharing by holders, and it also gives examples of such terms and divides them into terms that are unfair in and of themselves, it will always be unfair, and terms that are presumed unfair but with a relatively high bar of evidence can be shown to not be unfair on a case-by-case basis. But whenever a term is unlisted, the Data Act also, in the list of unfair terms, the Data Act also provides guidance on how to distinguish unfair terms, and it has a general unfairness provision. And now we can also see that the Data Act pays specific attention to matters of interoperability in a multi-stakeholder digital value chain. In Article 28, the Data Act specifically deals with the obligations of data space participants, and it establishes that, first off, dataset parameters must be described and machine readable. So these parameters can include data quality, data collection methodologies, formats, so forth. Meanwhile, technical data must be described and viewable. APIs and the terms of APIs must be described and machine readable. And data space participants also must provide the means to enable interoperability of data sharing contracts within their services. So there is a specific obligation towards this. And notably, the question arises, how should data spaces, which are partnerships of multiple entities, deal with these responsibilities? Is everyone responsible for every responsibility all the time? Well, thankfully not. A data space is given the option to allocate responsibilities for each of these requirements between the participants. Further, the Data Act also introduces provisions for smart contracts, which, as we already mentioned, will be quite critical in enabling the tracking of IP rights across data. The proposal stipulates that smart contracts where employed should be robust and allow for access control that is reliable and secure. They should have the ability to be safely terminated and interrupted at any point, and they should offer an equivalence of protection and legal certainty to that of regular contracts. Finally, smart contracts should protect the confidentiality of trade secrets as well. Taking a step back and viewing all of these provisions from the Data Governance Act and the Data Act, we can draw a few conclusions. The first of which is that there are still unresolved challenges in IP, tracking, subsistence, licensing for data and digital value chains. But even with this unresolved problem, we are already seeing new rights and obligations being introduced. We can also see that there is a marked emphasis on interoperability for data that signifies the growing importance of a common language between data space participants, cross-sectoral or otherwise. So from this, it seems to be the case that data and data interoperability are more and more becoming objects of legal regulations. And so naturally, these legal concepts must also be reflected in metadata to allow for their automated tracking. And the best way to facilitate such tracking and to reflect the legal concepts might be a shared top-level metadata framework that reflects both IP concepts and novel data rights. So because of this consideration, we in Ready and at KUL have started work on a legal ontology of IP rights with the goals of first establishing a common and machine-readable vocabulary of IP rights, which will hopefully be useful in removing bottlenecks to data deployment in European data spaces and assisting in the management of proprietary IP. It would also assist in the tracking of IP rights over multilateral digital value chains. So here I must, of course, preface this by saying that I am a lawyer and not an ontologist. In fact, I am brand new to this field. So I fully anticipate that there will be a great need to improve or maybe overhaul the ontology. But for now, the goals related to the ontology are first to define the various IP rights, such as copyright, patent, trademark, and to have each right also be described in terms of their criteria. For example, we can see that copyright has to be objectively identifiable, has to be precisely identifiable, and has to be a work of authorship. Of course, each of these criteria can be defined with reference to law and case law. And this is where we can use the annotations to provide a nice big list of various related relevant legislation. So meanwhile, in terms of criteria, it's not just the substantive legal requirements that should be set out to enable proper tracking of IP, but also the data requirements for each intellectual property right to be registered and to be recognized. For example, we can see here how patents, which may be granted through one of several pathways, including a national pathway, an EPC patent pathway, and a PCT patent pathway, are described in terms of what their application must contain. So, for example, An EPC patent must also contain applicant ID, a patent claim, and a patent description. And we can, of course, zoom in to each of these criteria and have, for example, an explanation of what the patent description should consist of. So we can, for example, identify that patent descriptions should include the background art, the industrial application of the claimed invention, the invention itself, and the technical field of the application. And of course, IP is always in reference to actors and processes which seek to transact with the IP rights. So the ontology naturally has to account for what are the legally significant actions that one may take in regard to objects that have IP protection attached to them, and also which are the classes of actors in the IP ecosystem. Further, there is also a need to clarify licenses and licensing conditionalities, even discounting the previously mentioned uncertainties regarding the suitability of data licenses being modeled on software licenses. We can also benefit from a shared understanding of what data can be used for under its licensing regime. So, for example, we can see here a breakdown of what, for example, the Creative Commons 4.0 International Attribution License allows someone to do. In this case, the permissions and the requirements are laid out. And of course, all of this comes with a rather significant amount of complexity, where each data right, each process, and each license has many conditionalities, properties, and requirements attached to it, all of which come together to elicit quite a long list of properties that must be kept track of. So with these goals in mind, while the ontology is currently taking shape in a basic form, the next steps are clear. First off, as I already mentioned, I would certainly have to go deeper into the field of ontologies and make it reflect best practices in ontologies, which I am sure it does not currently. Furthermore, the various IP rights must all be defined with their criteria laid out in detail and references to law hopefully provided. Then the various licensing families and their provisions should be described and delineated. And once this basic skeleton has been established, we can start branching out. Our partners in Chalmers in the READY project, which Michaela mentioned, are set to develop, for example, a resiliency ontology of their own, which would interface with the IP ontology and further remove hurdles from digital value chains and provide a great deal of interoperability for all matters of resiliency and IP tracking. And then there is also the chance to branch the legal ontology out beyond basic IP rights and reflect other categories of relevant data governance, such as DGA, DA concepts, GDPR concept, and so forth and so on. All of these attach to data and must be kept track of in an automated fashion, which an ontology would certainly be useful for. This brings us to the end of my presentation here, and I would just like to take a second to thank first Michaela at ICF for both facilitating this presentation and being a driving force in the project that listed it, but also to Yves Wimon-Wiehoff, a colleague at KU, whose work on IP rights really served to stimulate the effort to start this ontology and to identify the problems that need addressing. And now I think we can open the floor to questions or critiques about how bad the ontology is.
Thank you. Thank you. So any questions from the room straight off? Oh, we have a few. How are we going to deal with the microphone? Or do you want to tell me and I will try and...
People at home can hear very well also in the room.
They can hear very well. So if you speak loudly, I guess
Yes,
that's the recommendation. So shall we start with Gerhard? He was the first to raise his hand.
Yeah, very interesting. Thank you. And I learned a lot. I was just wondering right at the beginning, you talked about data and, cannot be IP, and there is like pure data, compilations of data. And so is there actually a definition elucidation that according to some framework, I mean, we use Flority, for example, for what the definition of data is, that underpins the legal framework, because otherwise, it's number one data, is, picture data. What is data?
So different legal instruments have different definitions of data for their own purposes. A commonly used broad definition is any representation of facts or information. So that's many of them look at data broadly. Rather than defining data in a narrow sense, what typical IP instruments and bodies look at is the qualities of the data. Does it represent authorship, originality? Does it represent something that is more than an abstract mathematical function or equation? So it's not so much about defining data itself, but attaching properties and qualities to it that must be met in order to allow the elicitation of IP rights.
Because it seems that for the ontology, that would be the key starting point, right? Because otherwise it's hard to assign anything to it. Or maybe that will help to assign things to it. What I mean?
Yeah, agreed. And in that regard, that's why the ontology seeks to attach criteria to each IP right, both in terms of substantive legal criteria, is something original, is something technically innovative, but also data criteria. Has this procedural requirement been filled? Has this information been given? So we are seeking to address that challenge and make sure that everyone in the ecosystem knows exactly what kinds of data they need to include to elicit an IP right, and what qualities the object of the hoped for IP right would have to have.
Thank you. Sam, I see you were also raising your hand.
My question may be simple. I suddenly saw the slide where you raised that data interoperability becomes a legal matter.
Mm-hmm.
So I didn't see the part, that you explained how did data interoperability become the legal matter. Maybe I missed it. And if so, then I guess you would have to have a legal definition of data interoperability, I assume.
That is actually true. So first off, why the interoperability and how did it become a legal matter? Well, we can see specific provisions that oblige people to ensure interoperability, whether it is within data spaces, whether it is within the course of data intermediation services, or whether it is in the context of cloud switching. So we can see all of this in the Data Governance Act and the Data Act. Like I mentioned, there are specific provisions that say these actors have these obligations to ensure interoperability. And that's why it becomes a legal matter. And also we can see that the legislator seeks interoperability by obliging data space participants, for example, to have their various data properties, their API terms laid out in machine-readable formats. So the goal of that is to ensure interoperability, as is the attention towards smart contracts. So that is how data interoperability becomes a legal matter and how legal obligations attach to interoperability. And as for defining interoperability, that is actually a very good point. And that is, I think, something that should be addressed within the law with some more specificity. But I assume that we shall see the judiciary, the courts, deciding on where interoperability ends, where it starts. So you are right there.
And perhaps warrants some recommendations from the OntoCommons roadmap on this front. I think there's something we can do about that. Anna, you also had a question.
Yeah, when you talk about rights clearance, do you mean consent of the data owners, so to say?
Yes, basically tracking who has given what permissions for what uses over data.
That's good. I think then we should talk. I was part of the coordinating team of a project that built a platform to actually manage consent.
Oh.
And it smashed it. It ended in December 22.
When you say that, do you mean like a consent management platform for personal data or for non-personal data?
Kind of both.
So under like IP or something like
GDPR.
the GDPR? Yes. Okay. So that, yes, absolutely. We should get to talking.
It's so it gives the users so all the rights over their data, so they the whoever wants to use the data can come to Smash it and say, okay, I need to build this application, I have this automatic contracting tool who also regulates this, and the users are then contacted not a number of times to give consent, so minimizing this consent fatigue or however they call it, and the user on the other hand has then a platform where they can see all the places where they give their consent. So, and we have an ontology also behind it. So.
Yes, amazing. I remember a few years ago when I was doing my master here at UIO, CMPs were all over the place and frequently did not really meet the requirements of the GDPR. So it's great that you actually took this initiative and
we worked with a legal team in University of Hanover, the IRI department, who gave all the legal fundament for this.
We should certainly have a coffee and talk.
So on that note, actually, I was going to raise the question of fairness, the fairness regime for data terms, which sounds to me like an attempt for regulation to ensure some kind of equity in representation. But that also feels like labeling, or feels like it feels rather superficial compared to the content of the data sets and the fact that we are not dealing with the data biases that are inherent in the data sets, which are inherently always biased. So that bias is not a bad thing necessarily. Bias is something that is done for a particular purpose of application. But you also mentioned that you're trying to encourage sandboxing and safe harbor practices. So what we just heard from Anna is actually also incentivizing a particular change in behavior, right? Would I be correct in saying so? And in order to manage the biases in data and not take them for granted, or rather to follow the provenance, to actually start to understand what kind of data we are inheriting from others, etc. It does require also a change in practice or change in behavior in terms of understanding. So would you say that this recommendation for sandboxing and safe harbor practices could allow us to test the new kinds of behaviors that we can encourage in order to, let's say, annotate data sets, the content of data sets, and to establish common practices where we can start to understand about the data rather than just do the labeling exercise, which seems to be the case?
Yes. So first off, before getting to the heart of your question, just to clarify about the fairness regime. The fairness regime is a matter of competition and contract law. So it's not meant to be fair in the sense to eliminate data biases and ensure data quality and safeguard individual rights. It's simply a matter of very dry competition law that says you should not give some businesses preferential terms compared to others. So just to clarify that part. But to the actual heart of your question, yes, absolutely. I think that from my recent discussions, even I was at Luleå speaking with technical experts that were part of the effort to make a European federation for data hubs. And all of them were kind of expressing frustration with the fact that complying with the DGA, for example, would be beyond just difficult, also restrictive in the sense that they would have to meet the requirements pro forma, but not actually get to the heart of
The issues.
the issues, yes, of understanding their data sets and of eliminating inherent problems with bias and control. So I don't see this as something that is a problem with these laws in themselves. They don't necessarily have to address this, but there is certainly a need for further initiatives, sandboxing or safe harbor for research or otherwise that would enable this.
Yeah, absolutely. So, my impression is that we're dealing with wrappers and containers, whereas we're not really addressing what is inside. And this is where the value, and in the long term, the value for IPR. So the intellectual property, the social value you would want to register in order to conduct a business is actually inside those wrappers. So, and this is because at this point in time, this is all we can do because we are not really capable of dealing with it. So I think there's a huge amount of work to be done on that. I saw someone raise a hand. Oh, we got a few. Okay. Someone in the back row, but I have to apologize. I can't see who you are. Can you please introduce yourself as well? Because my glasses are for reading and not for... Maria, oh, hello. Hi. Maria, hi. Maria, please ask the question. If you can do it as loudly as possible, because you're right at the back. Would you be so kind? Sorry, it's just you're so far away, it's very difficult to hear. Thank you.
Yeah. So it is really impressive that you did all the work organizing, coding that into Protege and so on. And I realized some bits that maybe you want to have a look at the Creative Commons ontology, that they already model some of the properties that you were modeling.
Great.
And open data rights language, that is the OGRL web W3C standard for open data rights rules and policies and so on. I don't know if you know about that.
No, I did not, and I am very grateful, very grateful, sorry, I'm just so excited, very grateful for these suggestions. This is precisely what I hope to get from participating here. So could I just take a minute after this to speak with you?
No, it's okay. There will be quite a lot of discussion during the coffee break, and we are coming up to it. Jim also has a question, so we'll take Jim's question first, and then we can all go and discuss over coffee. But also, I would say that this is exactly what we need. Thank you so much, Maria, and I was fully expecting her actually to have some really good suggestions. And also Barry Smith, who unfortunately had to take a plane to the US this morning, was saying that he would like to actually work to expand this. So the idea is that we have an overarching legal ontology that actually is inspired by this one, and that we expand it with all of these other ones, connect to all the other ones, so that we actually have expand the legal ontology field as such to all of the different application areas. So this will be a working group that you can expect to have next. So we can all align on this. So thank you. Was there something else, Maria, you wanted to? Yeah, we'll continue over coffee. Jim, please.
Yeah, so I have a whole note card of questions.
Oh, that's another coffee discussion.
We're on coffee break. So I'll limit myself to one question. So as I was discussing with Michaela, I spent a lot of time working in the agriculture industry, and data generated on the farm is a very big deal. certainly in the United States and in Europe. And one of the big challenges is around data rights delegation. So a farmer, you said that people don't own data. I completely agree with that approach. I've been arguing that for a few years. But farmers own their data. That's the way they think of it. So is the framework, ontology you're working on, does it consider the data rights delegation aspect of data that would include things like a farmer has data, a farmer grants rights to a service provider, and those rights would be, you can only do this stuff with data, you can only retrieve aggregated forms of my data, you do have permission to share my data with another third party, or you don't, all those sorts of things?
Yes, exactly. So that is what was part of the ontology. That was the part delineating the various kinds of actors, such as assigner, assignee, to describe the roles in a data delegation or transaction of rights. And also that ties directly to our effort to delineate licenses and license conditions, where we say this license grants you the right to use it commercially, this grants you the right to share it